Well, hello there and welcome once again to the Disability Law Show. We're back. John Scholes, Sivan Tumarkin here as well. Of course, disability lawyer reachable at help@disabilityrights.ca. And use that phone number every time, 1-855-821-5900. Consultations will not cost you a penny. So added incentive to pick up a phone and to make that call to Sivan and his team. Lots to cover on the show today. Short and long-term disability. What's the difference? We'll drill down on that in the second segment of the show. We got some phone calls coming through, some emails. It's always a busy show, always a busy half hour. So tuck in. We got a lot of ground to cover. Sivan, we always start off with the week that was, or case of the day. What do you got cooking today, pal?
John, it's great to be here with you and with our viewers. Let me start off with something that I think some people have forgotten about, which is COVID. I know we're not supposed to say that word. This is, 5 years ago, 4 years ago word, but the reality is we still have long COVID cases. And I was just talking to one of my partners, our friend James Fireman, who was mentioning to me that he just resolved a claim, a long COVID claim, with a long-term disability insurance company. And, he was able to settle it really, really well for his client. The insurance company had paid a lot of money to resolve that claim. And what he reminded me, and I want to remind our audience, is that if you or someone is still suffering from long COVID, maybe you're experiencing a whole host of symptoms, brain fog, respiratory issues, there's a whole host of things that are associated with long COVID. It's just not gone. It's an illness that we have to deal with. Remember, if you are suffering from long COVID or any other illness, and as a result of that, you can't work, you're unable to perform the essential tasks of your own job, of your own occupation, then you should be able to apply for short-term and long-term disability and get approved. But the reality is, John, that many insurance companies are refusing to approve these claims, or they'll approve them and then they will subsequently start hounding the individual for more and more documentation and at some point cut them off. So, we get individuals who are calling us, who are saying, look, I was diagnosed with long COVID, and as a result of this, here are the symptoms I have and I can't work, and the insurance company is refusing to pay my claim. And so we take on those kinds of cases. Now, there are some lawyers that I know, actually, that I've spoken to, who are not interested in helping individuals with long COVID because, again, it is not an easy claim to advance against an insurance company. From our perspective, if an insurance company cuts you off or denies your claim, and it's not right, it's illegitimate, the doctors are saying that you are disabled, you're disabled, you can't work, you need to recover, you need to undergo treatments, we'll take on that claim. We'll fight the insurance company. And again, John, as you mentioned, it doesn't cost anything to speak with me. Any member of my team, we work across Ontario, BC, Alberta. We have offices in these provinces, but the reality is we work across the country. We advise people on their legal rights when it comes to long-term disability claims and short-term disability claims across the country. And we do this for absolutely free. We've been doing this for years. And John, we like doing that. We like answering these questions. But I wanted to, again, start off the show with long COVID because, again, it's rearing its head. It's never really gone away. And there are people who are still suffering from it. And it's important people understand that you do have rights. Insurance companies can't do whatever they want. And if you are denied your long-term disability claim or you are cut off prematurely your long-term disability claim, we can help you get the money you deserve from your insurance company.
Beyond the fact that they like to dig their heels in anyway when it comes to paying claims, Sivan, why has there been so much pushback? Because we've talked about long COVID before. Why is there so much pushback with the COVID piece from insurance companies?
Well, there are several reasons. The two main reasons are, number one, it's difficult to prove that you have COVID. You can do a test, of course, but the insurance company nowadays, they're kind of dismissing it. They're saying it's like the flu, it's like a cold. That's the kind of things anecdotally that I've been hearing people tell me that their adjusters are telling them. Yeah, you can just get over this. It's just a cold, right? So that's number one. Number two, these cases have not yet been tested, as far as I know, in court. And so insurance companies are playing chicken with people, right? They're telling you, look, we think you can go back to work. We think that you're not disabled enough. And so we're going to push back and we're going to say we're not going to approve your claim or we're going to deny your benefits. And the reality is that if you let the insurance company just trample over your legal rights, if you're going to let the insurance company do whatever they want to do to you, then you're going to be in a situation where you are going to lose a lot of money, and it's money that is owed to you. And that's the reality. And you need to understand that you have legal rights, and we can help you advance those legal rights and recover the money that's owed to you by the insurance company.
James, obviously very strong. He's on this show all the time. You know he's pretty effective, so he got a great final piece on that particular claim. What would happen if these claims started going to court?
Well, that's a good question. I believe that judges will hammer insurance companies. And I think that as a result of this assessment, I'm not the only one who shares this. James shares it. There's other colleagues of mine who do. I think insurance companies know that they're going to be told by judges that they have to pay these claims, and they have to pay a lot more money. Because remember, we're not just claiming for benefits. When we go after an insurance company, we're claiming other types of damages as well. We're saying that they've acted in bad faith in some instances. We're saying that the individual has suffered through the fact that they were incorrectly and unjustly denied their benefits. And so we're going after them for other types of damages. And so I think that if this actually goes to court, I think insurance companies are going to find out the hard way that they should have approved these claims from day one. But until that happens, we have to keep fighting and we have to keep protecting people who are vulnerable and who believe that insurance companies have all this power when I'm telling you they do not. You have a lot more power than you think you do.
Not to dig into the weeds too much, so say one goes to court, you get a favorable ruling on this for your client. Now, does that become part of public record that people have?
It does.
Okay, now I think we're getting the reason.
It becomes a precedent.
Yeah, okay.
Right?
That's
precedent,
a problem.
Absolutely.
That's a problem with the insurance companies.
And insurance companies hate that because they understand that that weakens their argument, that makes their claims, their denials that much more difficult. And so, again, listen, this is a game for them, okay? They understand that they can only push so far, and they know that with some lawyers they can push more than with others. They know that with some individuals, some people are more vulnerable than others. They know this. They know this, and they take advantage, unfortunately. And again, this is the reason we're doing this show. This is the reason we're doing the radio shows. This is why I'm talking to people. I'm telling you, as a lawyer, as someone who does this day in and day out, answers these kinds of questions, speaks with my team daily about these cases across Canada. I am telling you, you have a lot more power than you think you do. Don't let the insurance company get away with it. This is your money. It's owed to you. The insurance company collected premiums. When it comes time to pay, they don't want to pay. We force them to pay.
Before you even make that phone call, we tell people the email as well, Pocket Disability Lawyer. Tell me about it.
So it's a website we created a few years back. I'm very proud of it. It's fantastic. You know, most people, when they have questions, legal questions, medical questions, any questions, they go to Google and they try and Google this stuff. Or they'll go to an AI chatbot. But here's the problem. A lot of times you will get information from incorrect sources, maybe sources from outside the jurisdiction where you're in. Let's say you're in Ontario or in Alberta or BC or wherever else in Canada. You may get information that's inaccurate, outdated, and just incomplete. What we've done is we've created this website. It's anonymous, it's quick, it's accurate, it's updated, it has an algorithm, and it allows you to get answers to your most basic questions when it comes to short-term and long-term disability claims. So go onto it. You know, there are a few pull-down menus, drop-down menus, and you can just get initial answers to the questions that are most pressing to you. What happens if I'm denied my claim? What happens if the insurance company asks me for this document or that, or wants me to see one of their doctors? If you don't want to call us initially, if you don't want to email us, go to that website, get the information right there. If you don't want to contact us afterwards, just close the browser and we won't even know you were there. But if you want to reach out after to get a more in-depth conversation going, again, at no cost, by all means, you can just click the button. But it's a fantastic website. It's been used thousands of times across the country. Again,
pocketdisabilitylawyer.ca is the name of that website. I think we got time before we get to email later in the show. We got a quick audio question, so we'll listen to that, Sivan, and get some answers happening as well. Listen up.
I've been on LTD for almost a year. Lately, my insurer has been emailing saying I need to respond to every request for an update. They say if they don't get an immediate update, they won't be able to approve payment for this month. I feel almost frozen with stress. I'm worried that this will result in a cutoff of benefits. What can I do?
Stressful for
This is very, very stressful, John, and it's very inappropriate for the insurance company to be hounding this person like that. Look, insurance companies have an obligation under the law to treat their insureds with respect, to treat them properly, equitably. And what I find a lot of times that it depends on not the insurance company, but the adjusters that work for the insurance company. Some adjusters are reasonable. Some of them are friends of mine. Some of them are simply not acting the way they should. They know that, but they also understand that if they can apply pressure on people who are vulnerable, they know that some people will simply get off claim. They'll just give up on their legal rights. So to answer this gentleman's question, look, you have to provide answers and documentation and follow-ups, etc., to the insurance company on a reasonable basis. It doesn't mean that you have to get back to them within 24 hours of them calling you. It doesn't mean that you have to get documentation to them on a weekly basis. No, that's not what that means. Now, it's a case-by-case basis on what's reasonable, but I'll tell you, John, I've yet to see a situation where someone was cut off because they didn't answer quickly enough when we're talking about days or weeks or even months sometimes. Insurance companies have an obligation to act reasonably with individuals. Now, again, case-by-case basis, so I don't know a lot of information here about this gentleman, but clearly he is in a very difficult state. Clearly he's in a situation where he feels that he's becoming more anxious. Here are the three things that I would tell you to do in this situation. Number one, communicate with the adjuster in writing by email, saying, you've been hounding me, you've been asking me for this information, I'm going to get it to you. Make sure it's in writing so that later on, if they cut you off for any reason, you can point to that email and say, look, I've communicated to you that I'm doing my best here to try and get this information to you. Number two, get updated medical documentation or a report or a letter from your doctor, confirming you're still disabled, confirming you're undergoing treatments. Nothing big, but just something that confirms to the adjuster that you're continuing the struggle and you're doing everything you can to get better. And number three, don't panic. Understand that these insurance companies can't do whatever they want. They don't have unlimited power. We are here for you. And look, this is a question that was posed to us, John, that was given to us, that was left to us as a message. But I'm always happy to pick up the phone, do a Zoom call, whatever is necessary with anyone. If you have questions, now, later, it won't cost you a dime. Connect with me, a member of my team, and we'll answer your questions. We'll go through your case individually with you. Again, no obligation, nothing. I just want to make sure that you understand you have rights.
And with that, we'll take a first break of the show, a short one here. When we come back on the other side, the main topic, short-term and long-term disability. What is the difference? We will cover that off when we come back. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, we are back. Thank you so much for hanging through the break. The Disability Law Show continues. John Scholes, Sivan Tumarkin, of course, reachable anytime, and his team. Make that phone call, 1-855-821-5900. Consultations will cost you $0, which is a nice benefit. Back it up with an email. How about that? help@disabilityrights.ca. All right, main topic time, Sivan. Let's get into this. The difference between short-term, long-term disability. Key differences, that's really the first question. What is it? What are they anyway?
Yeah, I mean, the key difference really is the time frame for which you're getting the benefit. Short-term disability, usually getting paid 3 months, 4 months, 6 months, and not every employer will have it for you. Not every insurance company will provide that. But if you do have short-term disability, typically, let's say it's 3 to 6 months worth of payments. Long-term disability is exactly what it sounds like, long-term. It usually kicks in after that short-term disability period. And that can be, generally, I tell you, the majority of policies, LTD policies, will take you to age 65 if, in fact, you continue to be disabled until that age. But there are exceptions. There are some cases, limited cases, where you have a 2-year policy or a 5-year policy. In some cases, you have golden type policies where it's beyond age 65. Usually you have to purchase certain riders for that. You have to have a certain policy. Here's the most common misconception when it comes to this point, though, John. A lot of times people think that they only have a 2-year policy or they only have shortened disability, but they haven't checked. And really, you have longer than 2 years. Again, remember, most policies, after shortened disability, the long-term portion, in most cases, will take you up to age 65. So if you need that, please, please, please understand that you need to look into your policy, you need to ask your employer, you need to ask your insurance company to make sure you have that. But that's the main difference between short-term and long-term. It's the time period for which you're getting paid.
So if someone is currently on short-term and they know it's coming to an end, maybe they've applied for LTD but has not been approved yet, panic sets in a little bit. I mean, what do they do?
Well, okay, so first of all, again, I tell people don't panic. It's easy to say, but when I say don't panic, I also follow up with saying if you are panicking, you are concerned, you give us a call. I don't care. There's no bad questions. There are no stupid questions. People don't know this information, right? This is information that is within the purview of the insurance company. The test generally for getting long-term disability is the same or very similar to short-term disability. So if you've been approved for short-term disability, it stands to reason that if your condition hasn't improved or you're still disabled, you should be able to get long-term disability. Not always, okay? There are hiccups with this, but you shouldn't panic, okay? What you should do is, if your situation is more long-term, well then, if you've been on short-term for a month, for 2 months, for 3 months, start asking questions, start looking at the paperwork, start talking to your doctors about helping you get the long-term disability, the long-term piece. You don't want to have a delay in between them because that does happen sometimes, and that means that you're not getting any money during that time, right? So you want to make sure that you do that. But again, people are concerned with the transition. I'm not going to tell you don't be concerned at all because insurance companies sometimes don't approve you for LTD when they should. But again, this is why we are here. We are here to give you this information, to work with you. And John, every case is individual, every case is different. I have seen cases where people just zoom from short-term to long-term disability, and I've seen cases where they ought to be, and yet the insurance company says, no, we're not going to approve you for LTD, and then we get into the picture, and then, of course, we resolve it in favor of the individual, etc. But don't panic. We are here for you. We'll answer your questions. We'll help you out.
So if you're sailing along, you're getting your payments either short-term or long-term, all of a sudden they stop. They stop. Again, what do you do in that situation?
So one thing to consider, usually these benefits, once you're getting them, they don't just stop. In other words, the insurance company typically will not simply tell you, hey, listen, John, guess what? The last paycheck, that was the last thing, the last benefit you were getting. No, they'll give you a heads up. They'll tell you they're not going to approve your LTD application, or they'll tell you, we've been paying you up until now. We think that this is coming to an end in a month, in 2 months, in 3 months. So they give you a heads up. And what I tell people is, look, as soon as your spidey sense kind of tells you that there is a problem, as soon as you've been told that your benefits will end and you feel that no, they should not be ending, you're still disabled, give us a call, email us. Let's talk about your case. I want to see the letter you received or the email. I want to understand what your condition is. I want to understand what your doctors are saying. And if I tell you that, no, the insurance company should not be cutting you off, should not be stopping your benefits, you can take that to the bank. We can help you make sure that the insurance company continues to pay you. That's the reality. If you do nothing, well, guess what? They're going to stop paying you. So absolutely, John, if the insurance company stops your benefits, give us a call. If they're telling you they're going to stop your benefits, and they shouldn't, because you're still disabled, give us a call, email us, get the information you need, empower yourself. Unless you reach out to us, I can't help you. I can't. I can give you this information, but you need to be able to act on it. So again, John, for everybody out there to understand, you have more rights than you think you do. You have more power than you think you do when it comes to insurance companies.
Reach out to Sivan and his team anytime. Again, that phone number before we get into a quick break here, 1-855-821-5900. Consultations are free as well. More emails and more audio questions on the other side of the break as we continue the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. Thank you so much for sticking around through the break. Reach out to Sivan and his team anytime by phone. It's a good way. Consultations won't cost you a penny. Just pick up a phone, 1-855-821-5900. And the email is help@disabilityrights.ca. I mentioned email. We'll get to that momentarily. I want to get to the second audio question of the show, Sivan. So here it comes. Listen up, pal.
I recently got notice that my disability is going to be cut off. And it's been about a year, but my doctor still thinks I need a few more months to see real recovery. The claims adjuster advised me I could appeal this decision. How do I go about doing that? And what support do I need?
The old appeal, huh?
The old appeal, but I want to break this down, John, because this is not unusual for me to get as a series of questions. So, number one, insurance companies prematurely cutting someone off benefits when they should not. That, to me, immediately triggers a legal right remedy. What does that mean? It means that if you have been prematurely stopped, the benefits have stopped, and you're still disabled. I don't care if it's for a few months more, if it's for the foreseeable future. The point is the insurance company has breached its contract with you. Remember, your relationship with the insurance company, with your disability insurance company, is a contractual relationship. There is a contract. You have obligations. They have obligations. You have rights. They have rights. Your right is to continue getting paid while you are disabled. Their right is to assess your claim on an ongoing basis. Okay. But if they then make the wrong decision and cut you off, and you now are not getting the benefits that you are owed under the contract, that is a breach of contract, and that's when we come into the picture. Now, I want to talk here about this appeal thing, this word that was just thrown around. And again, John, it's something you and I have talked about endlessly. Look, when you are cut off or denied short-term or long-term disability, the insurance company will send you a letter or an email, and they'll explain why it is that they're doing what they're doing, and at the end of that correspondence, they'll say you have the ability to appeal this. What is an appeal? An appeal is you playing in their sandbox. An appeal is you playing by their rules. An appeal is you essentially re-asking the same people who cut you off in the first place to reconsider their decision. Why would they do that? Now, I'm not saying that appeals never work, okay? But then again, lightning can hit you as well, right? You can win the lottery, but why take that chance? There's a much more powerful way of going about this, and that is to start a legal claim. That's where we come in. We correspond with the insurance company. We tell them, you better reinstate this person, you better pay them benefits, or else. And what is that or else? Well, that's taking it outside of their power and control, putting it in the legal system, and then once they understand that that's coming, they understand that they're going to have to pay their lawyers to deal with it. They're going to start bleeding money by paying their lawyers. One thing this individual here mentioned, John, is that his doctor still thinks that he should be off work for a few more months. I've seen cases where doctors have said, look, I think maybe a few more months of therapy and you should be okay. But it depends. Sometimes people regress. Sometimes the doctor says, you know what, I thought that a few more months would be okay, but no, I actually think it should be another 6 months, another year. Maybe it's indeterminate. We don't know. For the insurance company to cut a person off because they think that they can save a few bucks, that's completely inappropriate, illegitimate, unjust, illegal, and something that we can help with, and we do help with each and every day. So if you're in that situation, we can help you. This gentleman here, I will speak with him after the show. We'll go through his case. I'll explain to him what his rights are. Do not appeal this decision. I think in many cases, one letter from me or a member of my team is sufficient to get the insurance company to reverse course. And if they don't, well, guess what? You have a legal remedy. We can help you with that. Won't cost you anything to speak with us. Won't cost you anything to get this advice from us. There's really nothing to lose. Let's chat. Let's go through your case privately, and let's make sure that you understand what your legal rights are. But don't panic. We can help you.
I want to get to an email from Gil now. Gil writes in, says, I suffered a mental breakdown for extreme stress and overwork. With support from my family doctor and psychologist, I started a gradual return to work plan. Before I could resume full-time hours, I was fired. Now my depression and anxiety are worse. My doctors told me I'm sure about this, but they're still cutting off my LTD, saying I can work. What can I do?
So this is really, really unfortunate and something we see often, John. When somebody is experiencing a difficulty, symptoms, which are preventing them from doing what they need to do to do their job. In many cases, it's mental health related. In some cases, it's not. In some cases, you have a disease that's progressive, and what do people want to do? They want to hold on to their jobs. And sometimes, before they have the opportunity or the time to apply for disability coverage, for long-term disability, they get cut off. They get fired. And you know, what I tell people is, look, immediately go ahead and make a claim for your disability coverage, but then you may get a denial because the insurance company takes the position you're no longer covered, even though your disability actually arose when you were employed. So, you know, there are different ways of approaching this. Number one, if you're in the situation that Gil is in, we can help you. Number one, we can help you with your disability coverage to get the benefits you're owed. Number two, you were let go clearly as a result of a disability. And we have employment lawyers, Lior Samfiro, my partner, many other lawyers at the firm that can help you with that. There's a human rights element there as well because you were let go while disabled, while experiencing disability. So there's a whole host of issues here that we can help you with. Very important to understand. But, you know, there's a broader issue here, which is that if you are suffering from anything that prevents you from working, an illness, a host of symptoms, an injury, a combination of any of these things, don't wait until it's too late. Don't wait until you are let go from your job because you can't do your job. If you feel that you need time off, speak with your doctors, get the necessary treatments, get the necessary help. Apply for short-term disability or long-term disability, whatever is available to you. Make sure that you take that step. If you are denied your claim, we'll help you with that. But at least do that before you are let go from your job. Again, I'm not saying that if you've been let go from your job because you're disabled, we can't help you. We can help you, and you should reach out to us. But what I tell you is that what I'm saying is make sure that you take that proactive step of applying for disability coverage before you are let go, before it gets to that point. And then, of course, John, I can only imagine Gil and his family are extremely stressed. Sure. He shouldn't be at this point. We can help him. We can make sure that he gets the benefits he's entitled to from the insurance company. Certainly, we're going to deal with the employer. My colleagues at the firm will handle that. And that's another thing, by the way, that's quite unique about our firm. There are other law firms and lawyers that say that they handle disability claims and employment law. I can tell you that there are very, very few firms that I'm aware of that actually have that dual expertise. They truly do long-term disability law and employment law. And those two areas of law oftentimes overlap. And you need to have expertise in both. Otherwise, you can handle one but miss parts of the other, to the detriment of the individual. So again, Gil, we can help you. Please reach out to me after the show, and we'll make sure to take care of you.
Want to get to Veronica very quickly here. This is from mydisabilityquestions.com, another free outlet for you to ask your questions. She says, I've been on LTD for the last 2 years, and I was told that I do not fit the definition of the policy to continue receiving payments. I'm not sure what that means. My doctor says my condition is quite serious, and I likely won't be able to return to work for several years. What are my options?
I'm so happy that Veronica had reached out, John, because many people, when they're being told that they don't meet the definition beyond the 2-year mark, they simply give up. They think they have a 2-year LTD policy, that's it. That's the expiry date for their benefits. No, absolutely not. The vast majority of LTD policies will pay you beyond the 2-year mark, but the test changes, the qualification criteria changes. Initially, for the first 2 years, you have to demonstrate that you can't do the essential tasks of your own occupation. Beyond the 2-year mark, the test is any occupation for which you are suited for by training, education, or experience. And I think that's what's happening with Veronica. The insurance company has told her that they believe that she can do some other occupation. But John, I hear this all the time. People contact me and say, look, I'm still disabled. I can't do anything else. Certainly nothing for which I'm trained for or have education or experience in. And so the vast majority of cases and people who come to me and say, look, I've had LTD for almost 2 years, and the insurance company just cut me off or are telling me my benefits will end, we can help you get benefits beyond the 2-year mark. Pick up the phone, call me, speak with me. Let me explain to you what your rights are. Don't give up. Don't let the insurance company keep money that is owed to you.
Veronica, thank you so much, and that'll do it for this week. That came from mydisabilityquestions.com, free and anonymous for you to use anytime. And always follow up with a phone call, too, to Sivan and his team. Free consultations, 1-855-821-5900, help@disabilityrights.ca. And we got you covered. We'll see you next week right here on the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.